Hi, welcome to the Lawcast. My name is Melanie Thorley and I'm the director here. Now, first of all, this is going to be my last regular podcast. I will be posting podcasts from time to time, and I may in the future pick up another regular podcast, but today is going to be the very last one of this series. So thank you everybody for watching and listening to the Lawcast over the last few years. It has been a lot of fun. We have gone through loads of different cases, loads of different scenarios, loads of different legal shows. We have done it all. And today I am going to talk through cases where an employee has claimed that they were terminated and the Commission did not agree. Now, I have a number of them and they all came up basically on the same day. I've got three here that were decided on the 18th of March, and I've got two that were decided on the 15th of March. So these all came down in the same email to me because, of course, I get all these emails with all the decisions. This was in one block email. So I'm going to start with the two 15th of March's ones, and then we're going to go to the 18th of March ones, but you'll see that there's a common thread here. Now, in this particular case, the applicant, Michelle, filed a general protections application on the 9th of October. Now, by the 31st of October, the respondents had replied by saying there was no dismissal. So she wasn't able to file a dismissal dispute general protections application. Now, this is about an applicant looking for time off. The applicant was was in the office and she needed to kind of manage people. And it was a small practice which she was managing. The applicant's mother was initially scheduled to go into surgery on the 29th of September, and she was approved for leave that day because it was pre-approved. She later asked the respondents if she could work on that date, but confirmed she was unavailable because of her mother's surgery. Now, on the 21st of September, the mother was offered an earlier date of the 22nd of September because of some sort of cancellation. Now, this is all about dates, so I'll put them out there, but don't worry about listening to them too much. It's really about rostering. So this woman was basically told she could take this day off if she could find someone to replace her. She was rostered to work from 7:30 to 5 on the 22nd of September. But she couldn't. She said she was approached to ask if she could change her rostered shift to the following day. Both witnesses agreed that the respondent said words to the effect that if the applicant could arrange to have another employee called Jen attend work, then she could have the leave. So it wasn't a no, it was just kind of, no, this is too last minute, we can't really afford to have you not here. And he said that he wasn't confident that Jen was going to actually say yes because Jen wasn't feeling very well at the time. Now, she then contacted her co-worker Jen, who confirmed that she was able to work, but she was only going to be able to work between 7:30 and 3. Now, the applicant said that was what was happening to the respondent, and the respondent said, "Fine, look, if you can go and work from 3 till 5, all is well. Off you go. You can do the thing in the morning, come to work, and then do the thing in the afternoon." The applicant said, "I'm not doing that, I'm going to do this other thing instead. Family comes first." At the time, the requirement that she attended work from 3 p.m. At the time, the applicant, so her name is Michelle, is arguing that she was required to go back to work at 3 p.m. and that is actually a termination of her employment, because she had previously agreed to allow her to take the entire day off, and it showed a lack of empathy. She expressed an understanding that she had been granted leave for her mother's future appointments, and took this as an acceptance by the respondent that she could take leave to assist her mother in her cancer treatment as needed, irrespective of the amount of notice that she needed to give. Now, on the 26th of September, the applicant emailed the respondent seeking a separation certificate, and he replied back that it was never his intention to terminate her. And then in his evidence, he said that he took the applicant's email to mean that she wasn't returning back to work. And that's fair enough. A certificate of separation is a document that Australians can ask for from their employers once that employment has ended. So he was like, yeah, but I didn't fire you. When pressed on why Michelle understood the respondent's words or actions to be communicating termination, she said, "It was the way he spoke to me and the aggressive manner and behaviour. I had no option. That was the way it was going to be." Ultimately, when pressed, she thought that her employment had been terminated. She said, "I had no option but to leave and put my family first. I don't believe he was trying to find a fair resolution for both parties." Now, the respondent's argument here is that he did not have the authority to hire or fire employees, that he would needed to consult with the managing director, and that would be their decision whether or not to terminate. And that he asserts that on the day that he says that on the day that Michelle says she was terminated, he had not had any conversations with the managing director about termination. Now, despite Michelle expressing the view that she was forced to resign and she was forced to choose between her family and her job, she maintains that she was dismissed, not forced to resign. Michelle accepted in her evidence that the respondent didn't use any words that expressly conveyed termination, or words such as termination, dismissal, being fired or sacked. And in this case, the commissioner accepted the respondent had no intention to dismiss her, and that he wanted to find a solution to the problem of the business required a receptionist to work during that time, and that also that she wanted to be with her mother. His lack of authority to dismiss the applicant also asserts that he did not intend to dismiss her. So the Commission found that there was no termination. The Commission also went a little bit further than and said, look, he sympathises with Michelle because if she did have to come back to work, it would have been a bit of an annoyance. It would have taken time, it would have cost her money to do the hospital thing, come back from the hospital, go to work, finish her job, then go back to the hospital. But that was a choice that she had made. So that was not dismissal, number one. This went all the way to a hearing. Okay, second one that went all the way to a hearing. So this is a Mrs. Ho, and she applied to the Fair Work Commission for an unfair dismissal, and she's arguing that the termination happened and took effect on the 19th of September. Now, the problem with this one is that it's also 115 days out of time. So Ms. Ho's employment with Schnecker started on the 20th of June 2016. On or around the 21st of October, she was absent from work for workers' comp. And then from August the 23rd, the employer began a process inquiring about her fitness to return to work, including requesting meetings and medical certificates. So she stopped coming to work on October 2021. By August 2023, the employer's going, what's going on? On Friday the 15th of September, the employer wrote to her warning her that they were considering terminating her employment on the grounds of abandonment. On the 19th of September, they wrote to her again saying that her employment was terminated. When it comes to delays, and remember, this is 115 days out of time, the Commission need to consider the reason for the delay, whether the person became aware of the dismissal and when it had taken effect, any action taken by the person to dispute the dismissal, prejudice to the employer, merits of the application and fairness between the parties. Now, on the applicant's evidence, she says the reason for the delay in lodging her application included being unwell and unable to cope with her termination, and that she did not know her rights. Now, the Commission said it's not unusual for people to be unwell, it's not unusual for people to feel stressed about being terminated, and it's not unusual for people to not understand what their rights are. That is not a good enough reason, exceptional circumstances, to say that the delays were okay. She hadn't provided any medical evidence that she was too upset to file. She did provide some medical evidence, but that all dated back before her termination. So she gave evidence that when she finally learned about her options, it was around Christmas time and she didn't want to deal with it and couldn't cope with it. Look, at this point the Commission has made the decision to say no. So we didn't even look at whether or not she was properly terminated or whether she had abandoned employment. So in this case, I say another action from an employee who really didn't have any chance of success there. 115 days late is really long. It's quite an extraordinary amount of time. And she blamed everything. She blamed the union not getting back to her quickly enough. She blamed the fact that she was medically unfit but didn't provide any evidence to that. So there was a lot of blame going on there, and the Commission just weren't interested. So now we move to the decisions on the 18th of March. Now, in this one, it was Rosaro and Rio Tinto. So Rosaro filed a general protections application dismissal dispute, and the respondents filed a jurisdictional objection saying the applicant wasn't dismissed. Now, the evidence is that the applicant on the 15th of November made a request for annual leave between the 27th of December and the 29th of December. He gave evidence that there was evidence from the respondents that the Christmas year period was really popular for employees to take leave, and that because they all wanted to leave the site, and leave requests were usually received well in advance. The mines remain operational over Christmas and they needed employees to run the mine. Now, the respondents also said that on the 28th of November, the applicant's request for annual leave the request was denied. Then on the 28th of November, the applicant's request for annual leave was escalated for a review, and on review he decided to refuse the request because the warehouse required the applicant to work those days, and that was refused by the 29th of November. He had a meeting, and the respondent explained in that meeting that the applicant explained that meeting he wanted the leave to go to Perth for a 3-month checkup, and his medical records were in Perth and he had a cough. Now, the respondent said why the checkup had to occur during the Christmas break and whether it was a medical emergency. Now, the applicant said no, it wasn't a medical emergency. So he asked why he couldn't take leave before or after sort of that Christmas period in January. And the applicant said on both those times were available for the applicant to take, the respondent said both those times were available for the applicant to take leave. If he had updated the leave request, that leave would have been approved. Mr. Richter said the applicant told him it wasn't a medical emergency and that his family had flown to Perth on the 13th of December. Mr. Richter also asked the applicant if he'd sought, medical assistance from the medical practitioners in a nearby town, and he'd said no. He'd asked, well, you've been relocated here for several months, why didn't you relocate your medical records? He said he hadn't. Mr. Richter then told the applicant that if it was a medical emergency, he could take the 3 days of personal leave, but he would need to provide medical certificates. And the applicant said no, it wasn't a medical emergency, and that he was looking after his physical and mental health. Look, it's unsurprising that this leave was refused. The applicant then said he was forced to resign, even because of his extreme distress and his concerns for his safety. Now, Mr. Richter said in his oral evidence that he explained at the meeting the operational reasons why his leave application was refused, and that if it was a medical emergency, he could take the personal leave. Now, later that same day, the applicant sent an email to Mr. Richter, and it said, "G'day. I understand I'm on probation, and my performance on the job has not been satisfactory. I'm sorry I had mistakes in going Grove House. I'd not sort things out in my resettlement here. I take this opportunity to thank Rio Tinto for giving me a chance to work here, and for the warehouse team who've been so patient and understanding and supported me while I carry out my assigned tasks, learning and continuing improvement to the best of my ability. This is my notice of resignation. I am unable to continue working with motivation, peace of mind and dedication under a management who does not care for health, safety and well-being of its worker. Best regards." Now, a little bit later, about an hour later, about the same time the next day, on the 19th of December, Mr. Richter sent an email to the applicant under the heading Notice of Resignation, accepting and acknowledging the 1 month notice period. Basically, Ross, I acknowledge and accept your decision to resign. Based on you providing 1 month's notice, your final date of employment will be the 17th of January. Though you have indicated in your email that your health, safety and well-being was not important, I assure you it is the most important to all of the people who work here, and I wish you the best in all your endeavours. Now, about 20 minutes later, the applicant sent an email to Mr. Richter under the heading of Notice of Resignation, requesting to stop the dismissal because the case had still not been heard. Okay, so on the 3rd of January, a 372 application was allocated to the Commissioner's Chambers. On the 4th of January, an email from the applicant seeking to withdraw his resignation. Mr. Richter said on the 4th of January he received an email from the applicant, who also copied in a couple of other people with the subject line, withdrawal of resignation. Good day, I've been unwell and too distressed to think rationally. I was mistaken and would like to take back my notice of resignation and continue working. Now remember, this is after the leave with which he wanted to take. The termination of my employment would place my family in considerable financial hardship, unable to pay for the return of my car, belongings to Perth. My wife would be unable to start work at Grove Hospital, and the well-being of my 2 children would be affected. Mr. Richter did not respond to the email, but sent it to his HR, and the applicant worked up to his final day on the 17th of January. Now, on the 15th of January, the Commission conducted a private conference, and the matter couldn't be resolved. Now, the respondent submitted that at the conclusion of the meeting, which is that one back then when he said he wasn't going to approve the request, and after which the notice of termination was given, the applicant confirmed that he would work during Christmas period and did not appear emotional or upset, and the resignation was received approximately 4 hours after the meeting, did not contain emotional language or refer to directly the refusal of annual leave for the reason for resignation. Remember, this is a general protections application, dismissal one at that. General protection applications are about exercising a workplace right and being adversely treated because of it. So, on the face of it, it's really difficult to see how an adverse treatment has happened for an exercise of a right. Yes, he's been refused a leave. That's not necessarily adverse treatment, and it wasn't for prohibited reasons, even if it was considered adverse treatment, because the reasons were for not because he had made the request, but because they didn't have the employees available to take a spot that he was going to vacate. Now, it did not contain emotional language or refer directly to the refusal of annual leave as a reason for resignation. The acknowledgement and acceptance of the resignation was communicated approximately 24 hours later, and during which time the applicant didn't take steps to rescind his resignation until sometime later, which was the 4th of January. Now, the Commissioner decided that the applicant's argument that the resignation for the probable result was the probable result. The applicant's argument that the resignation was the probable result of the respondent's conduct is difficult to accept. He said, "I am satisfied that Mr. Richter did not refuse the annual leave request with the intent to bring employment to an end." So again, we're talking about an application where dismissal is needed to have happened. Forced resignation is where an employee is forced to resign because of the conduct of the employer. And in all these cases, the Commission has not found that the conduct of the employer is sufficient to warrant a forced resignation argument. Now, this one is about a Form F2, with unfair dismissal application. Sally was working for a company which provided beauty therapy to customers. Now, Sally lodged an unfair dismissal application claiming she was dismissed unfairly, and then sometime later the respondent filed a Form F3 objecting, saying that she walked off the job and there was further evidence of theft. This is a very kind of typical case we see in small business. Something happens in the workplace, the employer is looking at what's going on, put some allegations to an employee, they don't like those allegations, go basically silent, disappear, there might be a casual worker and never turn up again. The employer is small business and they're trying to do this themselves, and they're going, I have no idea what to do about this. And in the end, they send a letter of termination saying, we haven't been able to get hold of you, you did these things, we're going to terminate. Now, in this case, the respondent operates a beauty salon, and the applicant, being Sally, the respondent owner wasn't a trained beauty therapist herself, and she relied on other beauty therapists to actually do the therapy. Now, there's evidence that when the respondent sole director went on holiday, she had given some instructions to somebody else advising that she wanted a daily stock take to make sure that the products in the store weren't going astray. There was also evidence that the respondent herself had sent an email around to all the staff saying, we're not taking cash jobs, they all have to be done through the FPOS system. Now, on the 25th of September, the respondent sent an email to Mr. Wood advising him that she did not have a record of payment being made for his treatment. So this is a client, and asking him to confirm if he had recalled paying by credit card or cash. Now, Mr. Wood responded by saying, I paid $100 cash, it came to $90-something, and the rest of it was a tip. The respondent gave evidence that was supported by witness statements that she had made it clear that she wasn't going to be taking this sort of payment anymore. And that she also gave evidence that she tried to contact Sally, the applicant, multiple times between the 25th and 26th of December, discussing her concerns about the suspected time theft or theft of this cash payment. She also said that she turned up at Sally's house, knocked on the door was open, there was a fly screen in the way, and then there was this kind of hostile dog there. She got alarmed, she went back to the car and kind of beat the horn to try and get Sally out, and no one turned up. The applicant claims in her application that she was dismissed without explanation and only became aware of the dismissal when she wasn't able to get access to the appointments schedule anymore. Now, the respondent gave evidence that she received a text message from Sally's partner saying that he had left Sally's work uniform on her car in the car park. So on her car being the respondent's car in the car park. And the respondent gave evidence that by the 5th of October she determined that she needed to formally bring the employment relationship to an end, sent a letter saying, writing to formally terminate your employment, citing the unauthorised absence from work on the 27th of September, the theft of $100 in cash, the theft of retail products, and the breach of trust and ethical standards. Now, so we've got two kind of issues here on this final case. The first one being, did the applicant walk off and just not turn up and not deal with whatever was happening, and or did the respondent actually terminate? Now, the commissioner made the decision that there wasn't a walk off, that the applicant didn't resign from her employment, but she was actually terminated. But because it was consistent with the Small Business Fair Dismissal Guide or Code, then it was a fair dismissal. So it was a really kind of complex matter. It went on for many pages, and it was really about the facts of what happened. Now, the Small Business Fair Dismissal Code is a document that employers can rely on when they're terminating. If they terminate in accordance with it, then the termination isn't unfair. And in this case, it's pretty clear that we've got a situation where an applicant, being Sally, has been accused of doing something which is untoward and not consistent with her employment, theft, for instance, and keeping money and not turning up to work and getting paid for that day. And that Sally didn't want to face that. It's, the evidence doesn't say that Sally said she didn't want to turn up because she didn't want to deal with it, but she kind of didn't. And it's no wonder the respondent company made the decision to terminate, because they believed all this stuff happened. There was no evidence to the contrary. She tried to contact this person to find out what their side of the story was. So we've got basically tick, 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 the Small Business Fair Dismissal Code has been complied with. But it's just so what I always find amazing, and certainly about these 5 cases, they all went to hearing. We have an applicant who's done all these things in each of these situations, claiming they had no choice but to resign. Where are the cheerleaders here? So we've got issues where an employee has abandoned employment or stolen or resigned or has decided, because they didn't like being told they couldn't take the annual leave, that they had no choice but to resign. And all I can say is it must be those cheerleaders in the background. They can't do this. That's unfair. You should file. You are right. Now, I don't know if those cheerleaders are experienced in the area of IR law, or family and friends who aren't experienced but feel it's just not morally right in some way. But I am always, and people who have been watching this podcast for some time now know that I'm always amazed by the litigious nature of the employee when they have really no right to be. There's really no basis for that litigious action. There are genuine unfair dismissals out there. There are genuine general protection dismissal disputes out there. But that genuine case is getting bogged down by the big number of basically not genuine cases. And I'm fairly unpopular sometimes when I do my consults and I provide advice to employees, because I tell them what I see and I give them the information. I am genuinely unpopular sometimes because I am a very pragmatic lawyer, and I provide advice where I tell it like it is. I don't see a claim here. I don't see your outcome. What is your outcome here? You want money. The money's not there. I cannot see a commissioner offering that. I don't see the action here. And I am often a voice where I am saying, I don't think this is a claim that is sensible because I do not think your outcomes exist. Okay, I'm not telling the client that they might be able to get that money grab at the conciliation. I provide advice as to what I believe conciliations normally settle at. That is normally far different from my employees' position or what they wish to get. But it needs to be understood that this is not a jurisdiction where it should be okay for employees to make any action because they can, because it's cheap, because it's quick, and because it's easy. The reason why it's cheap, quick, and easy is for the true, genuine claims that get made. The actual unfair dismissals, the actual general protection breaches, not the people who feel a bit hard done by because they couldn't take the time off, even though the employer was trying to make it work, even though the employee has been accused of stealing and that employee doesn't want to come back to work and face the music. These matters should be considered with a better or different set of lenses. Look, I'm not here to lecture everybody. What I wanted to do is show you a little bit of the different side of these matters, not the crazy cases, whether they win or not, but the genuine applications for termination disputes where the commissioner just doesn't agree that the person was terminated. And there are a lot of them. So I hope everyone enjoyed my little bit of a rant at the end and the cases that came out in my final podcast. If you don't remember some of my other podcasts, or if you've seen this one for the very first time, you can go back and have a look and listen to those podcasts on Spotify and Apple Play, or watch the videos on my YouTube channel and enjoy them. There are plenty there. Again, thank you so much, everybody, for watching. And thank you, Phoebe Lee, who is behind the scenes on this. She has been a brilliant voice for me. She has been editing and she has been dealing with these podcasts since its inception almost. And she's been doing a brilliant job. So thank you very much, Phoebe, for all the help that you've given me over the years on this. And, you know, her and I will always be here. But she deserves a massive, massive shout out. And I'm actually going to shout out Mugu. I got a bunch of Mugu products from a client, and there was an unboxing in my last podcast, and I've been using them and they are bloody brilliant. Okay? Bloody brilliant. Thank you very much to the client who gave me the Mugu products. I love them. Okay, I'm not getting paid by Mugu to do this promo. I just think they're actually a really brilliant product. I've done this kind of spray stuff that stops bugs, that helps to stop bugs from being on my dogs when they're out and about. And I don't know, my dog smells great. They don't hate it, and no insect bites. So good news, everyone. And I've got this little paw stuff where it's paw balm, and I pop it on my dog's paws, and their paws are getting softer. It's very cute. Anyway, back to business. Thank you everyone for watching the final of the Lawcast. Thank you very much, Phoebe, for the help that you've given me over the years, and thank you to my listeners and watchers. You have all been brilliant, and there's so many of you out there. I'm not gone, I'm just not going to be around very often. See you guys later.